working day to attend this program. So, firstly, thank you for inviting me here. I thank ICSI IIP for giving me this opportunity to present this lecture. With this, we will start our session today. So, firstly, women in litigation. Let me speak on that because on this Women's Day special program, when I started in the initial days, there were several people from Bombay High Court, as in who said that in litigation not many women are there, and that was true because when I joined some 15 years back in the legal profession as a litigating lawyer, there was only one lady who was a senior counsel at that time. So, out of the entire community of senior counsels who were there then, there was only one senior counsel who was practicing in Bombay High Court. So that was the time then, and this is the time now when I see lots of young women who are there in the Bombay High Court, even in NCLT. If you ever watch the online proceedings, you will see a number of women, and especially young ladies, who are arguing vehemently, protecting their client, representing them in the legal field. So that way, if we see whether as lawyers, as litigating lawyers, as company secretaries, even as company secretary, we'll see a lot of women who are at the forefront now. So I feel that definitely the government, the institute, the community has done its bit in encouraging women, and that's why they have been able to be what they are today. And I think women's participation in the workforce, women participation in the legal community, women's participation as litigating lawyers, as practicing company secretaries, as in all walks of life is growing, and I think that is something beneficial because today they are at par, and the government and the community is doing all it can to protect them. So I think with this, let us move on to our main topic today, which is drafting, pleading, and arguments. Before that, let me see if I can share my screen so that I will be able to. Is the screen sharing on?
No, ma'am.
Okay, let me just see if you can view my screen. Are you able to view my screen now?
Yeah.
Yes. Okay, all right. So let us start with slideshow. See from the to start with drafting, pleading, and argument. Can I think there is some disturbance? Can all of you mute your mics, please? I think somebody's mic is on. Can you please mute yourself? Yeah, thank you. So, when I think of drafting pleading appearance on a lighter note, I always remember the Jolly LLB scene where a document is filed by Arshad Varsi and Justice Tripathi tells him, "What is this? You have called appeal an apple, you have called prosecution prostitution. ये क्या कह दिया है?" So हर लाइन में पांच पांच मिस्टेक्स है, एविडेंस पहले लिखते हैं. So this was a courtroom scene which was completely hilarious, where some document with multiple mistakes has been filed in the court, and the court is scolding Arshad Varsi, who was there, the jolly LLB. So this scene comes to my mind when I think of drafting and pleading, and which shows the importance, because had it not been a courtroom scene and had it been this kind of document, there would have been far serious consequences if such kind of documents were ever filed in the real court. So why study the topic? Today, NCLT, NCLAT are important institutions because the entire corporate field, whether it is companies which are doing well or companies which are in financial distress, are both going to NCLT and NCLAT. Why? Because, for instance, if a company is doing well, they want to restructure their capital, they have a merger, amalgamation, reduction of capital, or any such schemes, they have to go to NCLT. Or if it is a company in financial distress, they again have to take advantage of the IBC process, whether it is a CIRP process, a liquidation process, a winding up under the Companies Act, or whether it's a voluntary liquidation, or if it's a Section 95 petition. All this has to go to NCLT. So basically, NCLT and NCLAT are integral part of the system. And therefore, anybody today who is practicing, whether it is a chartered accountant, a company secretary, or as an RP, as a registered valuer, you need to understand how NCLT and NCLAT functions, because these are tribunals that are playing a very important role in how the corporates are functioning and how it is affecting them. So, in this, in NCLT, if you are practicing, what will be important aspects that you need to see? Because, for instance, now in NCLT today, there are multiple petitions that get filed. So how do we approach this topic? Because you are today, like, most of you are RPs, then there are people who are practicing as lawyers or as representative. Even a company secretary is representing in NCLT. So we find many a times they are representing the clients, they are filing the applications, they are representing in the court. So whether as an RP you are filing an application, or whether as an RP you are representing your matter, or whether as a company secretary you are representing, as a lawyer you are representing in court, these skills of drafting, pleading are extremely important. So, therefore, knowledge, at least working knowledge of these areas, we should get. So, now what I'm going to do is I am not going to go into the specifics of the law. I am going to give you a glimpse. For instance, if there is an IBC petition, I am not going to answer questions on how to file a Section 9 and what laws have to be taken into consideration. What I will do is I will give you a glimpse of questions which I will ask, and I will leave it at that. And it is for you to understand that when a Section 9 petition is filed, it is not just the drafting and like putting in records and details, but it is a far more intense exercise than that when you're trying to draft a document as simple as a Section 9 petition. So let us see. Section 9 petition. Who will file a Section 9 petition? We will start with a simple process as simple as who will file. Section 9 petition is there, or a Section 7 petition is there for that matter. Section 9, you will have to send a notice. There will be a reply to the demand notice. Accordingly, you will file the Section 9 notice. But in this, who will file this petition? Now, this issue had come up in multiple matters where a Section 9 or a Section 7 petition was filed, and they say you are not the right person who is filing it. For instance, Section 9 petition was filed in the name of the proprietor. They said, Messrs. ABC. The petition was dismissed. Even in NCLAT, it was dismissed. They said that a proprietorship firm has no separate legal entity. That petition cannot survive. So, Messrs. ABC was written and that petition was dismissed. Why? Because there is no entity which has filed this petition. They said this proprietorship doesn't have a separate legal entity. So, it will have to be the individual who will file. For instance, Mr. Mishra, proprietor of ABC. All right. So, because of this small thing, this matter had gone up to the NCLAT. So, who is going to file the petition will be important. In certain cases, debenture trustees had filed, but they did not have necessary authorization. In that case, the petitions were dismissed. Then, if the bank loan has been assigned to the assignee, whether they can file, whether the assignment deed is properly stamped, whether there are any complications in the assignment deed, whether there is a tripartite agreement, all these things, these issues about who can file, when can they file, are the issues which are raised in the courtroom. So, whenever you are filing a Section 9 or a Section 7 petition, you have to think before you file that what is the care that I need to take when I am filing a petition. Because if you look at the case laws, like in NCLT, there are thousands and thousands of cases now which have been filed. There are thousands of judgment you will find on Section 7, Section 9, and drafting makes a very big difference whether your petition, and the care that you take while drafting makes a very big difference whether the petition is admitted, number one, and how much is the time limit within which it is admitted. Because, for instance, if you make a mistake in the petition, the other side will point it out. Then there will be a discussion ki whether this defect is a curable defect or not. I'll give you a small example. Section 8 notice was sent. Certain invoices were attached along with those, because a company generally, when they are have a supplier, when he is having contracts with a party, they have multiple invoices. Like over the years they must have sent thousands of invoices. So what was done at the Section 8 stage is they said that all right, out of this 100 invoices, the last 20 invoices are not paid, so I will attach this 20 invoices to my Section 8 petition. Now, in the reply to the Section 8 petition, the other side pointed out ki baba, you have shown invoice number X, but look, this is the payment which I made towards invoice number X. Look, you have said invoice number Y is not paid, but look, this part payment was made towards Y, so therefore it is incorrect. So at the time when they filed the Section 9 petition, what they did was they attached all the 100 invoices. They were supposed to attach all the 100 invoices, but out of those, they attached accidentally one set of invoices which were already paid, and did not attach the invoices which were attached to the Section 8 petition. So this mistake, in the index it was written I am attaching all the invoices, and they forgot to attach the invoices which were attached to the Section 8 petition along with certain other invoices. They attached, say, only 60 invoices instead of 100. There was a mistake by the clerk. Now this mistake, which was a silly mistake of not attaching the entire 100 invoices, which perhaps could have been done by the clerk, resulted in a delay of almost 4 months in the hearing of the petition. Because the first argument from the side of the corporate debtor was that this petition is for a separate set of invoices, it is not for this invoice. Then they had to argue, no, but Section 8 petition is attached, so these invoices are not separately attached. So this was like a small mistake of not attaching the proper invoices, which caused a delay of 6 to 8 months in the petition, which finally was resolved because an additional affidavit was filed, certain clarifications were given. So, that post mortem would not have happened if adequate care was taken during drafting of a petition. So, this is just one of the examples that I am giving. Please tell me if I'm going too fast or too slow. Are everybody following me?
Yes, yes, please.
Yes,
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 please.
yes. So just let me know if there are any issues, okay, in the network or anything. Then I'll go fast or slow accordingly. Okay, so this was one of the cases. Uh, now we will deal with against whom the petition under Section 9 can be filed. So one is definitely, you will say, company and LLP, but it's not as simple as that, because Section 9 petition now, initially one of the petition was filed against a company which was struck off. It was struck off under Section 250 248 of the Companies Act. So petitions were filed against it. The CIRP started. In the middle of the CIRP, somebody must have seen the MC extract. They realized, oh my god, this company is struck off. And then the promoter realized that perhaps this can be an argument to safeguard my company from the CIRP. So he went and filed an appeal, went and filed an application in NCLT, and then went up to the NCLAT saying that you can't file an application against a struck off company. This application cannot be filed. So this became a landmark judgment where the court said nothing doing. Even a company which is struck off, you can file a Section 9 or maintain a Section 9 and a Section 7 petition against such a company. So that way, if you ask me, whom can it be, against whom it can be filed, is also an important aspect. As in, can you file it against a corporate debtor? Can you file it against a corporate debtor who is struck off? Can you file it against a corporate debtor under whom winding up order has already been passed? Now, under the Companies Act 1956, there were several companies against whom Section 95, Section 433 proceedings had started under the Companies Act. Under the Companies Act, an official liquidator was already in place. That official liquidator had taken custody of the assets. That official liquidator was in the process of selling the assets of the company, and certain creditors filed a case against such kind of corporate debtor in NCLT. So one argument was that when a company is in winding up, there is a section 446, which is the exact, not exact, but it is quite similar to section 14 of the IBC. So they said there is a moratorium and you cannot initiate any litigation or legal proceedings against a company against whom winding up order has been passed in the High Court and official liquidator has already taken over such a company. So in that case, there were a series of orders, some for and against, and somehow now the law seems to be settled. But I would not say settled because IBC law is still in a flux, so there can be conflicting decision. But as of now, the stand which was taken and which as of now stands is that because this has gone up to the Supreme Court stage. So the law as it stands is that you can file a Section 7 or a Section 9 petition against a company which is in winding up if it has not it has not come to an advanced stage. So if you can show that, look, official liquidator has taken control of the company but he has not liquidated the company, the assets are still intact, so it is possible that the company may be brought into the CIRP and it may fetch a better value. So if you are able to show this, then you can allow such a company to get into the CIRP process, and some companies have successfully done that. Now, another issue which came up was that, look, corporate debtor, okay, winding up petition has not been admitted, but winding up petition is pending against them in High Court. So why are you taking up this company here? Already there are some 7, 8 winding up petitions which are pending in the High Court. Why are you not letting those continue? And why are you hearing this application? This kind of argument was also made because these are initial arguments which can be made. And that's why when you're filing a Section 9, a Section 7, you will have to not just look at the facts of the case but also look at the legal proposition which your other side may come up with, and trying to find a solution and incorporate them in your petition itself. So I am giving you these examples because this has to be thought of before, because on the first date or on the second date they will raise a preliminary issue, file a maintainability application. So you need to have an answer to these questions beforehand. So these were some of the cases. Now, another major issue that went up to the Supreme Court, and this was heavily litigated, that when you had already filed against the principal debtor, can you still go against the corporate guarantor? And it depended on what time you had filed the petition. Because if you wanted to file against a corporate guarantor in NCLAT, there were two judgments. One was for, one was against. So in between, when there was a judgment that said that if you have already filed against the personal against the principal debtor, you need not file against the corporate guarantor. And there was another set of judgment. They say you can definitely file against the corporate guarantor because the uh, the debt is both parties are liable to pay the debt, and therefore the action against the principal debtor and the corporate guarantor can go on simultaneously. So this law as on now prevails, and there are several judgments to that point, but this was a issue which was taken up, because of which petitions were fought up till the appellate tribunal, up till the Supreme Court even. So just one second. Yes, again, we know that petitions can be filed against a company and LLP, but can petitions be filed against a government company? Some people try to file a petition against the municipal corporation. Why? because the law says any corporate entity, not just a company and LLP. So it says corporate entity. The law is applicable to a corporate person. So many people in the sense, some petitions were filed, not many, but a few petitions in India were filed against municipal corporations, say against BMC or against other municipal corporations, against a cooperative society, especially sugar factory. Sugar factory, some of them are companies, some of them are registered under the Societies Act. So they tried to file a petition against a sugar factory, who was a cooperative society, not a company. Then some petitions were filed against insurance companies. So can these petitions be filed? The answer is, in certain cases, I will not, as I told you, will not get into it, because then we will never move ahead. But such kind of issues are also there before the court, where they say this is a government company, can't be done. This is a company, like say for instance, a company is incorporated by virtue of a separate act, not by virtue of Companies Act. So all these issues are being raised in the court. So who is your corporate debtor? Can you file a case against him? Is something you should see before you venture into filing a section 9 or a section 7 or a section 10 petition. Then we come to financial service provider, because if it's a financial service provider, you cannot file a petition against them. So for instance, bank, insurance company, NBFC, BSE, NSE, and other financial service providers, if they can show that they are regulated by an authority, a regulatory authority like SEBI or RBI, they can they cannot come under this act, because there is a separate legislation, separate provisions for a bank to be dissolved. So they do not come here, and that is provided in the law. So therefore, that care has to be taken when you're deciding whom to file a case against. For instance, but in certain cases, I'll just give you an example. Uh, for just to give you an example, that NSDL is a clearing company, regulated, and therefore you cannot file a case against it. But in certain cases, they have demerged certain undertakings. So they have an arm which takes care only of the IT segment. They have an arm which take care only of the ticketing segment. They have an arm which takes ticketing, in the sense certain aspects of IT are given to a company, and some service provider provides service to the service entity, not to the ultimate financial sector regulatory authority under that. So in that case, you can file a case against the IT company, but not against the actual entity, which is a financial service provider. So that also care has to be taken, that when you're looking at an entity, you have to see whether that entity is a financial service provider, or that is simply a subsidiary of some financial service provider. The entity which is the main corporate debtor, their status as a financial service provider will need to be seen. Now, one important question that comes after we decide, all right, this is the corporate debtor, I want to file a case against this corporate debtor. What is the next question before us? So, the question is, which NCLT bench should I file my petition in? Because that also, at the time when you're filing a petition, you have to take care of specific questions which particular benches may ask, because so every NCLT bench has a peculiar way in which they deal with matters. So accordingly, you need to understand the courtroom also before you're filing certain petitions regarding what are the basic things, so that you can cover it in your drafting. So jurisdiction is an important aspect that you need to see. First is the territorial jurisdiction. So, for instance, if you have seen over time, the number of NCLT benches has increased. So, earlier, if you were filing a petition, say from Madhya Pradesh, in the initial days, you had to file that petition in Ahmedabad. Thereafter, Indore bench was set up in Madhya Pradesh. So, if currently you want to file an NCLT petition, there is a separate bench for Madhya Pradesh where you have to file the petition. Then Chhattisgarh today doesn't have a separate bench. So if you are appearing for a company, if you want to file a petition against a company which is located at, say, Chhattisgarh, all the matters are going to Odisha Cuttack bench of NCLT. So you will have to file it there. Later on, if a bench is established for Chhattisgarh, then you will have to file your petition there. So that way, Jurisdiction of NCLT has to be seen. If it's a company or a corporate debtor against whom you're filing, the place where the registered office of the company is situated, of the corporate debtor is situated, is important for the purpose of deciding territorial jurisdiction of the NCLT bench. So, if a company is situated, say, in Nagpur or in Mumbai or in Pune, you will file it in Mumbai NCLT. If it is situated in, say, in New Delhi, the matter will go to New Delhi principal bench. That way, your the registered office of your corporate debtor, the place where the registered office is, will decide where you file your petition. Second, this is the territorial jurisdiction. Now we come to the second type of jurisdiction, which is pecuniary jurisdiction. What is pecuniary jurisdiction? Pecuniary jurisdiction is the amount above which you can file. So, right now, with respect to petitions, and for section 7, 9, and 10, we have already seen it is 1 crore rupees. But now there is a lot of case law on whether principal should be 1 crore or principal plus interest should be 1 crore. So, if you see the series of judgments which have been passed, they had said, is the interest provided in your invoice? Is the interest provided in your contract? Is the interest provided somewhere? Is the interest accepted? Then can it be included? Can it not be included? Numerous case laws on that. So, pecuniary jurisdiction is also important. If your principal amount is less than 1 crore, which is the threshold limit, then you will have to take care to show how this petition is still maintainable in the court. Now, this is the pecuniary jurisdiction for 7, 9, 10. But there are other pecuniary jurisdictions for other types of petition, which also you need to take care. For instance, if you're filing a pre-pack insolvency, then your pecuniary jurisdiction is not 1 crore. For an MSME, to go for pre-pack insolvency, your pecuniary jurisdiction is 10 lakh rupees. If you're filing a section 95 petition against a corporate, against a personal guarantor, which I don't think currently is of any use, because it is 1000 rupees, and most of the claims today in NCLT run into crores. So that pecuniary jurisdiction as such is really not useful. But nevertheless, pecuniary jurisdiction is different for a personal guarantor. It is not 1 crore, it is 1000 rupees. So that way, the pecuniary jurisdiction also has to be seen. The third point is your subject matter jurisdiction. Subject matter is where can this petition be filed. For instance, no, not in these section 7, 8, 9 petitions, but in section 95 petition, this is a very important aspect. Because where do you file a section 95 petition? There have been a series of judgments on that. So that also care you have to take. So, Section 95 petition, if CIRP is going on, if, for instance, there is a ABC company limited, A, B, and C are the personal guarantors for this company. Now, if ABC limited is in CIRP in Mumbai, then the petitions against A, B, and C will be filed in NCLT Mumbai. But there is a further question, because the law says it will be heard by the bench where the main matter is being heard. So, this issue was also argued that look, my matter, there are 6 benches currently in NCLT Mumbai. So, they said, look, my matter is in court 1. You are hearing my section 95 petition in court 4. So, it has to be heard by the same bench which is dealing with the main matter. So many a times time was given for transferring the matter from one bench to another. So that way they tried to buy time in the matter. Then there came a NCLAT decision. They said nothing doing. It will be, the court says, the bench. That means NCLT bench Mumbai. So if you have filed a section 95 petition in Mumbai, that is enough. You have complied with the law. It doesn't have to be in bench 1 where the corporate debtors matter is pending. It can even be in bench 4 where the matter is pending. Now this matter most certainly will go till the Supreme Court stage. NCLAT has already said you can continue arguing the matter in NCLT bench 4 instead of NCLT bench 1. So this is the subject matter with respect to such kind of matters. Now, if ABC Limited CIRP is over, liquidation is over in that matter. Well, so this NCA ABC Company Limited is dissolved. Then, if a banker wants to file a Section 95 petition, where will he file? He will file it in DRT. All right. Then there were further complications. That look, resolution plan was approved in ABC Limited's case. We take a alternative case that ABC Limited, a resolution plan was approved. So when resolution plan is approved, CIRP ends. So you can say that petition will again have to be filed in DRT because there is no CIRP or liquidation proceeding pending against ABC Limited in any NCLT, because as resolution plan is approved, company moves out of CIRP. So such case was also there where they challenged the subject matter jurisdiction of NCLT, where they said, look, NCLT cannot take up the matter. So the bankers objected in this case and said no. This company resolution plan was approved, but that resolution plan, the successful resolution applicant could not comply with that resolution plan, and we have filed an application saying that resolution plan has failed and we want to liquidate the company, and that application is pending in NCLT. So still NCLT will retain its jurisdiction. So as you see that these are the complications in the matter. Like we are talking about such small thing as a jurisdiction of the court, but still in that small jurisdictional aspect there is a lot of case laws. So therefore you have to understand one thing, that when you're drafting is not just about facts. Drafting today, especially in IBC, is about understanding the legal propositions surrounding your petition. So, as simple as I told you, that even a Section 9 petition or a Section 7 petition or a small Section 95 petition, which is just filling up the form, many people feel it's just filling up of a form. It is not that. It is far more deeper than that, and you will have to take efforts, because otherwise, if you don't take care of these things and you don't think about these things at the time of drafting, they will come to haunt you at the time when you are arguing the matter. Are we clear on that? Anybody has any?
Yeah, I have a question, ma'am.
Yes.
Uh, let's say you have a new bench in Indore. Uh,
Mm-hmm.
one second.
All right, I think we have lost him. We will continue. You can ask your question. If you can hear us, you can ask your question a little later
Sorry.
after we
Yeah,
complete.
yeah,
Yeah, yeah,
yeah.
please tell me.
I got. So let us say you have a bench now set up in Indore,
Yes.
and your matter is proceeding in Ahmedabad. Is there a system for transferring to Indore for locational purposes by the petitioner or the respondent?
There is a provision in the law in NCLT rules. You have power to seek transfer from principal bench NCLT. So that subject matter
Right.
of transfer of petition from one courtroom to another is only with the principal bench NCLT. So if you want such kind of transfer, you can always file an application and appeal to the principal bench. You can make that request and that application to NCLT, principal bench Delhi.
Yeah. Okay.
Anything else? Are we clear? Is it going like, uh, should I give more explanation or how is it? All of you, if you have any issues, just let me know. All right, let us move on. I think in the chat box. Okay. Yeah. So this is regarding the jurisdiction. So we have subject matter jurisdiction, we have territorial jurisdiction, Then there is one more type of jurisdiction. I wouldn't call it jurisdiction, but threshold limits. Because, for instance, for home buyers now, in section 7, there's a threshold. The way we had thresholds in operation mismanagement cases. For instance, in operation mismanagement cases, we had to fulfill 10% criteria to be able to file an operation mismanagement case. So, unless you are a shareholder who has at least one tenth of the total number of members, or 10% of the total share capital of the company, you could not file a petition. Similar such threshold limit has been introduced even in the insolvency code, especially for home buyers in certain classes. So, therefore, if you are filing an application for a home buyer, then you will have to find out whether you fulfill that criteria which is provided in section 7. 100 members, 1/10, that criteria you will have to fulfill. So such kind of criteria for specific type of matters also has to be seen before you file. Now that itself sometimes is a matter of great contention, because, for instance, if three companies are filing, there are three promoters, if there is a development where there are three co-developers, so all three have decided that one will take up, say, one will sell for out of the inventory 13%, another person will sell out of the inventory 50%, and the last one will take the balance. And you are filing the petition, you have purchased from one of these co-developers, and you have to decide the percentage. Now you are saying you will consider only the total inventory which is available, or only the inventory which is available with the developer with whom you have a agreement with. So these kind of issues will also come up. So for this, when you're practicing in NCLT, especially drafting, you have to take care of such issues also. So we have seen jurisdiction, we have seen who can file, against whom it can be filed. With respect to who can file, there is one more issue that comes up, that many a times company is in CIRP. So when company is in CIRP, the resolution professional generally finds that, look, there are these 10 people from whom more than 1 crore is recoverable, but they have not paid. So he initiates for the company a petition. So earlier there was a lot of contention whether section 11 bar applies, and whether a resolution professional can file a case under section 7 and 9 against other corporate debtors. But that issue is no longer res integra. Already courts have passed decisions that yes, you can file it. So who can file, against whom it can be filed, what is the jurisdiction. Now we come to the next issue, which is limitation. So limitation also you need to see, and limitation also a lot of care needs to be taken. If any one of you has seen the case of, like, you, if you have read the orders regarding limitation of the court, you will find 3 years. From which date is 3 years to be counted? Whether it is the date of default, or whether it is the date of NPA, or whether it is some other date. Whether if there is a part payment, if within 3 years there is a part payment, will limitation extend? If there is a part payment after 3 years, whether limitation period will extend? If you have an acknowledgement in the balance sheet, will the limitation period extend? If in the balance sheet you have mentioned, but along with that you have also mentioned that you have a objection to this amount, whether the acknowledgement will stand. So all these things regarding limitation also have to be taken care of. On a very, on the similar but a little different point is section 10A. Because if you have seen recently, many petitions has been dismissed on the ground of 10A. The latest one, the one which was mostly in news, was the case of IDBI versus Z. So IDBI had filed a petition against Z during the time when Z and Sony merger was under consideration. At the same time, a petition under section 7 came to be filed by IDBI Bank. Now Z said that, look, this application, the date of default is between March 2020 to March 2021. And if your date of default falls within this, then your petition will not be maintainable. So therefore, on this ground, they won the case in NCLAT. There is another matter in which same issue is being raised, is the Dreams 11 matter. If you see Dreams 11 right now, it was in news recently where a petition under CIRP was admitted against Dreams 11, the fantasy sports they play, online gaming. So it was a net worth positive company doing very well, but unfortunately a section 9 petition came to be admitted against this company. Immediately they rushed to NCLAT, and NCLAT has granted them stay on the same ground of 10A. So 10A and reading of 10A will be crucial if you are dealing with the IBC petitions, because many petitions are taking this objection regarding 10A. Even in section 9, that becomes important, and I'll give you an example. When you when you file a section 9, you generally ask the client that give me the list of invoices and the due dates of those invoices, and how much is the amount and how much is payable, and all that chart. That computation chart is generally taken from the client without taking much headache, because we don't want to get into the computation bit. We file the petitions. So I have seen so many section 9 petitions being filed, whether the due date of some of these invoices which are filed is between March 2020 and March 2021. So therefore, technically many a times it happens that your 10 invoices get deleted, because of which your petition becomes below the threshold limit, because of which your petition can be dismissed on the ground of non maintainability. Because say for instance, if you have 15 invoices and 5 out of those 10 invoices are say 10A barred, and the rest 5 invoices which are left are only 30 lakh or 50 lakh, then the court will say nothing doing, I can't consider your petition. So this has happened in several matters. In fact, we have successfully taken this as an argument while arguing such matters, and therefore you have to take care regarding the due date which you mentioned, especially in section 9 petitions. Those computation chart have to be personally seen by anyone who is filing this petition. One more aspect, like how do you sometimes get over this problem, because in drafting you will have to surmount the problems that you face. Because when you are filing section 9, you will know that all right, I have a 10A bar, so what do I do, how do I answer it? This is also an important part of drafting, because you will have to address the challenges that you will face in in the court. So you will know that these are the 10 defenses that may be taken against me. How do I prepare my section 8 petition, how do I prepare a section 8 notice, how do I prepare my section 9 petition in such a way that these objections will not be raised, or I will be able to find the appropriate answer for this question. So I'll just give you an example of how do you answer this. Now, as we have taken this example of uh, invoices, some of them being under 10A. For that, you will need to know certain other acts. You need to know Limitation Act, you need to know Companies Act, you need to know Sale of Goods Act, because in Section 9, it is mostly supply of goods which you are dealing with. So you need to know all that. So if you look at the Contract Act, it says that if a payment is made, you can, firstly, the person who is making a payment can apportion the amount. So if I am making a payment to you, say of 1 crore, I will tell you that look, this 1 crore should be appropriated against invoice number 1 to 10. I can tell you that. Otherwise, if I don't say that, then the other side, that is, the if I have paid you 1 crore, you can decide how do I appropriate that 1 crore. So many a times when in a running account amounts are paid, they are not paid towards specific invoices, but they are just paid as a part payment in a running account. So which is to the advantage of a person who is filing a section 9 petition, because then the apportionment can be done by you. So if you get 1 crore, you can say that look, this 1 crore has been apportioned towards making payments of invoice from March 2020 to March 2021. These invoices are paid. Rest of the invoices above and below are not paid. I have an acknowledgement, say a balance confirmation from them of the amount, and that's how you proceed in the petition. So that apportionment can be done by you if it is not done by the other side. So whenever you are drafting, you will have to find a way to cover the problems that you are facing. That is a very important aspect of drafting. And I would say that in drafting, please do not write too much, because the more you write, the more you will confuse. You will have to show debt, default, balance confirmation, acknowledgement. Stick to that. Do not write longish stories, because the moment you write longish stories, what people do is, I have seen section 9 petition which are running into, how many? They are running into 10 volumes. So in that case, it becomes very complicated. You need not put the entire documentation, entire email correspondences into your section 9. You have to show the relevant part without concealing anything, but you will have to show the relevant part. So if there are communications regarding certain regular communications between the parties, you need not show them unless the other side is going to later on say, oh, this was a dispute which you haven't shown. So that way you will have to be discreet in terms of what you need to show and how much you need to show. Now, let us move on from drafting of section 9 petitions, section 7 petitions, and all that, to drafting of applications. Now, in drafting of applications, I have just some of the applications which came to my mind, I've just written that, because these are applications which every RP in the regular course files. At least section 12, 12A, 19 2, they're the most common applications which are filed. Then section 30 applications, all these are regular applications. So let's deal with that. Whenever as an RP you are filing an application, or whenever as a COC member certain applications are being filed, you need to take care of the basics. So what happens is, people file an application under section 12 for extension of time. Court asks them, okay, when was the admission date? When was the date when you, what are the times when which you want to extend? What is the time you want to exclude? Where is the COC minutes? How much was the voting of COC? So when you're filing an application, always be careful that you should anticipate the questions the judges will ask, because section 12 extension also not is not given just for the asking, or an exclusion of time. If you are asking for an exclusion of time, saying this to this period has to be excluded, you need to give a justifiable reason to the court. And today the courtroom will not just accept, okay, it's a section 12, I'll not go into it and accept a exclusion or an extension of time. So today drafting plays an important role. So whenever you are drafting such kind of applications, you have to think and you have to analyze, because otherwise what happens is, many a times in the courtroom they start counting. Because court asks the, like, I'll just give you an example of a section 12 petition. Court asks them, when was the matter admitted? They have to go back, show the order. If you had given a list of dates, it would have been far more simpler. So how many periods are how much period is over till now? They have to compute. They have not computed. So are you asking for 180 days or 90? Are you is your 180 day, when, on what date was it over? Your 270 days, when was it over? Your 330 days, is it over? When was it over? Why are you seeking exclusion of time? On what basis are you seeking exclusion of time? If there was a stay by NCLAT, what was the exact nature of stay? Was it a stay on the entire CIRP proceeding? Was it a stay on the COC? What kind of stay was it? If you, many people were asking for exclusion at the time when Supreme Court had given exclusion of the Corona period. So even that today sometimes comes into the picture. So you have to attach all those judgments. You have to attach all those documents to prove what you are saying. So that way, anytime if any application is filed, whether it's a section 12, 12A, you will have to give the necessary documents. And that proof has to be attached. And that I'm giving you one more example is of section 19. First thing, when a CIRP process starts, within 5-10 days, inevitably, in several matters, you will see a section 19(2) application filed by the IRP. And that IRP says, look, I have to do that because I am protecting myself. Otherwise, questions will be raised tomorrow by the regulatory authorities. So I need to protect myself if they are not giving me the complete details, and I don't know whether these details are enough, which has been given. So in most cases, RP files a 19(2) application. And in several times now, when you file a 19(2) application, it is not the promoters, but the IRPs who are scolded by the judge. Why are they scolded? Because they say, what steps have you taken? You show us. So there, whenever you're filing an application before the courtroom, especially as an IRP, especially as an RP, you will have to focus. You can't just, because what happens many a times is that some junior is given the task of filing a 19.2 application, and they just put in two or three facts and file the application. Then the court asks them that what are the list of documents you want? Sometimes those are not attached. What are the steps you have taken for the purpose of ensuring that these documents come to you? Those are not attached. Then the court asks them, did you ask the statutory auditor for these documents? They are not prepared. Then the court asks them that look, you can see corporation cooperation from the income tax department, from the GST department. Have you done all that? So, what I would suggest is that many of you who are regularly practicing or who want to establish a practice in this field should watch the courtroom proceedings, because the kind of questions that the judges ask will give you a flavor of what are the documents that will be required. Say, for instance, the Section 19 application which is filed. You will need to show that look, this is the list of documents. Out of this, these 10 documents I have received, this rest of the documents I have not received. Look, these are the mails I have written to the auditor, these are the mails I have written to the promoter, these are the promoters of the company, or else you're not able to trace. Sometimes it happens that the company has not filed returns for 5-10 years, so you're not able to find even the basic details of the company. So all these things have to be put forth before the court. Don't take courtroom proceeding for granted that if I have filed a 19.2 I have done my job, because many a times then the court gets upset when incomplete applications are filed and the court's time is wasted. So be careful in any application that you file. Then let's go to section 12A applications. 12A are the most simple application, but there is a timeline, which is a directory timeline, that if a form FA is received, you need to file within 3 days. So many a times there is a confusion whether you need to file, you need not file. Sometimes that time period, there are issues. So 12A application needs a bank guarantee. Many a times the person who are settling, they're not ready to give a bank guarantee. So many a times the IRP stops the matter there, even though he's completely paid, saying that no, without bank guarantee can't be filed. But in many a cases, if you give an undertaking that I have received the complete payment and I have no objection to the bank guarantee being not given, in that cases the matter proceeds. So that way, what documents are to be attached, and if they are not attached, what is the rationale behind not attaching these documents also needs to be given in a document, in an application, so that the application is complete. Otherwise, as an RP, as an IRP, so many a times when documents are incomplete, they say call the IRP, call the RP. So it is, if you don't take care, or if your office doesn't take care of these applications, ultimately you will be hauled up in court to answer the question or to cover the gaps which of information which are missing in your application. So you have to be careful while you file this application. Now, who will file the application? Because many that there were instances where a section 27 application for replacement of RP was filed by the IRP. So replacement of RP, for instance, there are certain applications which are to be filed by the COC. So you need to take care regard who is given permission to file a specific type of application. Is it the IRP? Is it the RP? Is it the COC? So section 27 is such kind of application for replacement of RP which has to be filed by the COC, not by the previous IRP. So that care needs to be taken with respect to who is going to file the application. All right, then let us go to other applications. For instance, now if we have to consider filing a, just 1 second, I'll just stop them. Are we clear till now? Should we move on?
Yes, please.
Yes. Any queries? Any instances you want to share? Because all of you are practicing, many of you are practicing RP, so you also must have come across such kind of issues. So if you want to share. with the members. I think we can have a more interactive session.
Yeah, in case of Section 19, what you say actually was right. Uh,
Hmm.
so what we had done in our Section 19, in my first case, was we had given a list of all the meetings that we done with the promoter, and we had given a list of all the information that we had requested from the promoter.
Hmm.
So to that extent, the Section 19 was the judge was satisfied, and he said, yeah, rather than a roving eye kind of application, this is much better, and he appreciated this thing.
Super, super. Because especially in Bombay, unless the application is proper, the court comes down heavily on RPs. Only when the documentation and everything is proper, only then the promoters are hauled up. So let us go to another such application which is regularly filed is the submission of resolution plan. So for submission now, so for submission of resolution plan, for submission of resolution plan, the application that is drafted has to be very thorough, because whenever now an application is drafted, in many cases that has to be quite extensive, because your application will come up for hearing after some time, and generally when such application is filed, the COC is in a hurry, the SRA is in a hurry, everybody is in a hurry for the matter to go on. And that's why you have to be very careful in such kind of applications. So there, when it comes to a section 30 application or some such application which is of immense importance, you have to take special care in such kind of matters. So what will you do in such kind of matters? For instance, in resolution plan, the application, you will have to tell the entire history of the matter. For instance, you will have to show that you have followed the process and reached up to the resolution plan stage. So all those documentary proof, everything should be attached, because otherwise it will be something for which the matter gets adjourned. And as you know, if a matter gets adjourned, court has like 60 matters a day, their entire board is full, especially NCLT Mumbai, they have like 60 matters a day. And the next date which may be available to you will be after a month or a month and a half, because the NCLT Mumbai especially is heavily, like there is super heavy overload of matters. So therefore, if you want your matter to be expeditiously heard, you will have to take care while drafting of the matter. And how will you find out what needs to be done? So in that, you should always go back to the section first, the rules if there are any, or the regulations. So let us start by giving an example of a resolution plan application. So resolution plan application, there is a specific provision that says Form H has to be attached, a compliance certificate has to be attached. So you have to keep in mind that that has to be attached. You know, by reading of any resolution plan application, any resolution plan order, what are the documents that are seen. For instance, if you look at any resolution plan which is approved in Mumbai, you will find that they start with admission of the CIRP process, that this date the matter was admitted, this date the matter invitation of resolution plan took place, this date the COC was constituted, this is the constitution of the COC, this is the revised constitution of COC. Then they say that invitation of resolution plan was called for. Sometimes there is a revised invitation of resolution plan. Then section 29A objections sometimes are taken up, they go to the court, then they come back. Then promoter MSME, whether the promoter is an MSME or not, is one of the issues which has been raised. There are certain objections that will be raised in the COC minutes. And this entire story of what has gone on in CIRP. It is like a story that goes on. They are fighting. There is COC member. There is dissenting financial creditors. They have some or the other objections. Some are voiced. Some are given later. Some of the creditors vote. Some of the creditors dissent. In certain resolution plans, when there is just one or two bankers, they postpone the resolution plan approval indefinitely. For three months, they say we don't have necessary instructions, and therefore we will not be able to either approve or disapprove resolution plans. So many such issues are faced during approval of resolution plan. So this entire story of what all has happened along with the documentary proof should be attached and produced in the court. Now understand one thing, that this resolution plan application may have to be given to other parties. For instance, if the SRA, if SRA is there in the court, you will give a copy to him. Promoter, at times when they oppose the plan, they seek copy of the application, so that copy of your application is also going to them. So if there are certain documents like valuation reports which are very sensitive, because even during the during the discussion on the resolution plan, it is only the value in the COC which is shared, that this is the value, which is the liquidation value, fair market value of the company. You don't disclose the entire valuation report unless there are some proceedings and some allegations and they are asked to reveal. Valuation report, as a matter of course, is not shared in the COC meeting. So whether to file that in the application or not, all these are issues that you will have to see when you are filing an application for approval of resolution plan, and that care needs to be taken, right? So while drafting of an application, as important as a resolution plan approval document, because this is going to be a very important document, and everybody, if anything goes wrong, everybody is going to blame the RP. So in such kind of matters, you will have to be especially careful, because you will also have to show that the entire law is complied with. Because if the resolution plan gets rejected saying that no, it is not in compliance with the law, you as an RP will face several repercussions. So therefore you will have to be careful even at the drafting stage. If there are some objections taken by somebody, you need to be sure of what is going to be your answer, and those answers, certain factual aspect regarding those answers can be incorporated while drafting the I. So drafting of any application or any petition is basically about understanding the law, understanding all the case laws, right? And along with that, having the knowledge and having a crisp way in which you put it. Because many a times, certain people write all irrelevant facts also as a part of the petition. For instance, they are filing a section 12 petition for extension, and they will write everything about resolution plan, what happened, and all that the court doesn't need to know. The court will ask you ki, what is the progress in the matter, so that point wise you can give them the details, but you need not go and prepare a 1,000 page section 12 application. So based on which application you're filing, you need to know how much information has to be included in the application, because you want that application to be heard expeditiously. And if you want that application to be heard and an order to be passed, you will first have to take care that you have incorporated all that is necessary and you leave out all that is unnecessary. That is especially important in terms of everyday applications that are filed, right? So this is about drafting of applications. Just give me a minute, I'll be back. Yes. So shall we continue? All right. So now we have seen some of the regular applications that are filed, and again in that category there will be two other applications which are like I'm looking at it from the applications which are most regularly filed. So in that I can think of three other applications which are most regularly filed. Is one is an application for liquidation, one is an application for dissolution. In case of companies in voluntary liquidation, it is a company petition for dissolution. And there is then the plethora of applications that get filed under section 60 subsection 5, which is like a sundry provision in which all sorts of applications are being filed. So these are the application, especially in Bombay, which constitutes majority of the application. Because if I try to categorize the applications, these are the other three set of applications which are very common. So now, application of liquidation, you might feel that this is like the simplest of all applications. I will just have to say that why the company is to be liquidated. But if you see the current law, where the Supreme Court has said that liquidation is an exception, resolution is a rule, liquidation is an exception. Because of this, many a times, if you see that if it's a company with good asset, which was a running company, which you're pushing into liquidation, firstly, be sure that court is going to ask you a lot of questions. If combined with that, the promoter is an MSME, then the questions will double. If the promoter is an MSME and vehemently arguing, your questions will triple. If there are other resolution applicants against whom some resolution applications which had come but they have been rejected, or the COC is not, against questions will be raised, and you will, as an RP, you will have to be ready to answer those questions. So liquidation, which is considered to be like the simplest of all application, where you show that this is a liquidation application, this is the COC, they have admitted it, they have said with 66% I have accepted that the company should go for liquidation, and the time limit, or else the time limit is over, and therefore I am pushing the company into liquidation. So if you see, when the CIRP and the IBC started in 2016, 2017, out of say 100 companies, 70 companies had gone in for liquidation. There was a majority of companies that went into liquidation. COC said nothing doing, we are not accepting it. But now, as the matter, you're seeing many companies be liquidated, and companies which were doing well, which had employees being liquidated. The way in which the courts are now looking at liquidation has changed. And therefore, if you see percentage wise, I will not be able to tell you the exact percentage, but let me assure you, today the percentage of resolution is far more than the percentage of liquidation. And I think all of you as RP might have also witnessed it, that earlier in 2016, 17, 18, liquidations were very easy. Like many a times the COC didn't want to go through the rigmarole of the resolution plan. Midway, they used to say, no, we want to liquidate the company, and that would have been done. It was easy. But now it will not be easy. And many a times promoters do get a right to challenge it. In fact, in certain courts, when liquidation application comes up, court gives a date. Rather than deciding it on the same day, the court will give a date. He will say, okay, if there are any objections, we will see. You serve this on the promoters. So this has happened in NCLT Bombay several times, where they want to give a chance ki why are you liquidating the company. So it is not as easy to liquidate a company as it was earlier. Of course, the court will ultimately see what is the process followed, and ultimately, but questions will be raised. That you have to be sure, especially in, I'm talking about NCLT Mumbai and the matters that I have seen. So today the trend is towards saving the companies rather than liquidating it. So it has happened many a times that a liquidation application has been filed, liquidation application has been withdrawn. In fact, we have at times done that when a liquidation matter was filed, we appeared for one of the parties, we explained that certain period has not yet expired, there's still time. Because of the corona, we were not able to file our petition, we were not able to file our plan. We showed that we had the necessary money, We showed an FD account where the money was kept, and we say we are ready to make the payment to the bankers, the complete payment within 30 days. Please give us a chance. And the court has done that, because there are Supreme Court judgment that says that 330 days, yes, it is mandatory, but in certain cases, if there is a chance of resolution, a chance should be given to the party to try and explore and try to let the company survive. So such kind of matters have been there. So this liquidation application, though easy, at times can be a very complicated affair, running into multiple dates where there are opposition. The promoters come back, say we are an MSME, we should be given a chance. We were not given any chance of filing the plan, or some of the other objection if they have. They will find out mistakes which were done in the CIRP process, and they will try to challenge it and ask the court to give them an opportunity to place their application before COC. So you should be ready that chances were given to the promoters. You have given an opportunity to them. They have been attending all meetings. So this kind of proof you have to think before you file the application. So even a simplest application like liquidation will require you to put some thought process into what can happen and what should I write in the application that will fortify my case, and I will not have to present more and more facts as the matter proceeds. All right. So we have dealt with section 33. Now let us look at section 54, because even voluntary liquidation and other types of matters for dissolution, it comes for to the NCLT. So if there's a voluntary liquidation, you are appointed as an RP. You will be appointed as an RP by the shareholders. So shareholders will start the process. They will say that yes, we appoint Mr. So and so as a liquidator of the company under section 59. Voluntary liquidation process commences from that day. You will have to complete the process and then come to the court by filing an application under section 59 for dissolution of the company. Now, this was something which was like a normal process which was done very easily. But now, if you see the manner, the trend which is changing, and that's why you will have to look at the courtroom proceedings also. That's why I'm saying drafting, just writing some facts and putting an application is easy. But the thing is, if you want to do it effectively, you will have to know what are the latest trends. So you will not just have to look at the case laws, but also keep intermittently, because all NCLTs today are virtual. So if you just the courtroom, you can witness what is going on in the court at a click of a link. You can easily see what is going on in the courtroom. And if you look at what is going on in the courtroom, you will be able to do two things. You will be able to appreciate what are the kind of questions that are being asked by the court, what are the kind of apprehensions that the court has, and accordingly, you will be able to do better drafting and present your facts in a better way. Because at times court will ask you several things, and as RP you will, that facts need not be there in your document. They will still ask you what have you done, but what have you done with the property, how has the business stopped, why did you many a times it happens that the employees are retrenched to save on cost. Sometimes it does happen. So why have you done that? Because promoters want to raise all these questions. So you should also be ready with the overall facts, and this will be an important part which we will see at the time of arguments, because when we are dealing with the argument bit of it. But at the time of drafting also, you will need to keep these facts in mind. So if you look at a section 59 proceeding in the courtroom today in NCLT, you will find they are asking questions. What are the questions they are asking? In voluntary liquidation, they're asking, have you served it on the nodal officer? Now you will wonder, where is the nodal officer of income tax coming into the picture? Then you will come to know that yes, there is a standard operating procedure for NCLT issued by CBIC and CBDT. Many of the judges are referring to that and saying that have you given them a 90-day time limit? Have you informed them? So you just not so for practicing and successfully practicing, you will need to look at the latest trends also and what are the courts asking. Because if you have not served it, they might ask you to reserve that document. Again, you're going to spend 3 months time waiting for this. And I'm not getting into whether this is right, whether it is wrong, where the circular of IBBI, which says that you don't need to take permission of income tax under section 178. All these things are arguments, but ultimately, if you understand what are the apprehensions of the court, if you look at the court proceedings, you will be able to deal with your processes much easily. Because ultimately, you have seen that the courtroom, if they find that you have been lax in your duty, and that has happened with several RPs, which was unfortunate, but when the court found that you are not doing your duty, what they have done is they have simply written to IBBI, and that has in fact cost many IRPs their license, which has been suspended at certain times. So you will have to be extremely careful while you're doing that. You will have to show your bona fides, and that is not that. See, as they say, appearance today is also appearance is also effective, also important today. In today's day, you have seen जो दिखता है वो बिकता है. So therefore, I understand that you would have been very thorough and honest in following the process, but you will have to remember all that, because when you are in the courtroom and suddenly a question, like you already have a representative in the court who is uh, who is answering the questions, who is showing the petition, but the courtroom asks iska kya kiya, which the authorized representative may not know. So you as an RP, they will directly ask you, and then many a times the RPs are not ready to answer those questions. So therefore, that care will need to be taken. So now moving back to our section 59 petitions. So if you see the recent trends, you will see that nodal officer of income tax, nodal officer of indirect taxes, they are being a little concerned about government revenue being lost currently. So in Mumbai especially, they are asking these questions, that whether you have served a nodal officer of income tax, whether you have served a nodal officer of indirect taxes, that is at PCCIT. So you will need to see, and you will need to be ready with these arguments, or in the process, during the process, you will need to follow it and put the necessary proofs in your petition. Otherwise, in Bombay, because of these things, several petitions have been adjourned to 3 months to 2 months. So that care needs to be taken if you are if you have a time bound process and have to meet certain commitments to the clients. So this is just an example of the care that needs to be taken. I'm just giving you a few examples. Now let us go to section 60, subsection 5. Section 60, subsection 5, meaning that is like a Pandora's box. So if you are an RP, like in certain cases, we have seen that 60 odd applications were filed during a CIRP process under section 60, subsection 5. So that is like the favorite default section which anybody can use. So anything they have against the RP, anything they have against the process, anything they have against anybody, that will be filed under section 60, subsection 5. So what are the regular applications that get filed? One is promoters filing applications, where they feel that the process is there are certain iniquities in the process, they can file an application. Financial creditors these days are challenging each other's claim. So if, for instance, one banker's claim of say 100 crores has been accepted, somebody else will file an application saying that how can this claim of 100 crores be filed? This claim is incorrect. So these kind of applications are also being filed. In Bombay, we have seen an avalanche of cases with respect to real estate industry. So a lot of real estate builders are have gone in CIRP. So that is another instance where numerous applications are filed by home buyers. So this, like in one of the matters, we had out of 60 applications, we had 20 applications which were filed by home buyers. Some said that look, this home uh, this home has been prepared and possession has been it has been registered in my name, so this is not an asset of the this is not an asset of the corporate debtor, it is my asset. Some have said that I have taken possession of it, I have made payment, and I am entitled to this property. How can you take possession and custody of this property in the CIRP process? So, such kind of applications today are also filed. So, 60 subsection file is a be all, add all section. While if you are drafting, if you are an RP, you will be mostly at the receiving side of such applications. But in other times, if you're drafting a section 60 subsection 5 for any of the parties, you will need to put in all the facts. For instance, many a times uh, an agreement is terminated by the other side during the CRP process, and RP challenges it, saying that you can't terminate this agreement in the middle. This is an essential supply. Or your electricity has been shut down because you have not paid the electricity board. So there also an application is filed under 14 read with section 60 subsection 5 that this electricity has to be given back. So in that cases also, factual aspects and legal aspect had to be properly set out, that this is electricity, it's an important component, these days it has been paid. Now if you are an RP, you will know that you will have to pay during the CIRP process, at least for, say for instance, if you consume 100 units during the CIRP process and 1000 units before the CIRP process, you need not pay for those 1000 units before CIRP, but you will have to pay for those 100 units that you use during the CIRP process. So that facts will have to be put in. Otherwise, you're going to go back and forth. Judge is going to ask you one question, you will answer that, you will say, oh, I don't have that answer in my application. You will go back, you'll come back with that answer. The judge will continue the hearing, again ask you a few questions. Then all right, but what was it for? You'll again go back. So that back and forth can be stopped if you put in the necessary facts, right? And this is especially true for section 60 subsection 5. They ask for agreements, if for instance termination, when was it terminated, what was it terminated, how was it terminated, what was the application, what was the agreement between the parties, whether it can be terminated, whether it is an essential supply or not. In case of mining, details are asked regarding that. So you will have to be ready, because it will not just be on law point, it will also be on factual point. So facts, you will have to present all the facts in the application, in the petition that you do. But I would suggest, do not put in the law, because as you see, as in anybody who is in this field for the last few years, you will see that the law changes. The law in IBC is in a flux. So today, if there is one way that the courts have interpreted it, it is possible that the matter may go up in appeal. It is possible that a larger bench may pass a contrary judgment. For instance, stamp duty. You have seen the question of stamp duty, whether an unstamped document can be considered or not. The Supreme Court also gave one decision earlier and revised it in a matter of few months. So if you had put in that law point in the petition, you would face trouble, because the other side would immediately point out, look, they have shown this case law, and this case law has been rejected, this case law has been amended, so you are not entitled to it. So I would always suggest putting in the facts and not the law. Law, you can put it at the time when you are filing written submission, that is after the argument you file a document which summarizes what are your arguments. So that time you can show the law. Do not put the law in your application, because I've seen many, the RPs, the applications that they draft, they put in all the case laws, everything. It is okay at times, but as we have seen that the law changes, you can always point out one or two case laws and say that, look, these case laws are no longer applicable, their application is no longer sustainable. So that's why take care that facts, not law, are to be provided while you are drafting a petition, right? So with this, let us move on to the pleading part. In this, I will just start with a, well, whenever I think of drafting pleading, suddenly many quotes of the Jolly LLB come to my mind. So, if you have seen the courtroom drama that was there at the beginning of Jolly LLB 1, so they were arguing with respect to a particular doctor who has allowed his son to do a surgery of a pregnant lady. So that person gets very emotional, the doctor, and he makes several statements in the court. And Arshad Varsi, on his behalf, says, I'm very sorry, my client got angry. And the court said कि ये कोर्ट में सिर्फ मैं गुस्सा हो सकती हूँ. So that tells us something about the courtroom. That court, you have to be very careful. Courtroom pleadings, if you see leading lawyers, if you hear leading lawyers, they will always say that arguing in court is an art. Even if you know all the facts, even if you know all the law, whether you will be able to present it successfully is in a courtroom is a different ballgame altogether, because it requires a lot of soft skills, as they say, the art of advocacy. Why do they call it an art? Because it is about presenting the facts in a very persuasive manner. So, for instance, uh, if you just state the facts that okay, this 4 5 facts are there. Kindly give an order. That will not convince the court. You will have to give a beautiful story. So there was a movie. If you see, I think there was a very interesting movie which was about slaves, whether slaves are a property or not. So the entire movie is about a legal drama over whether slaves are a property or not. The matter goes in the first, the slaves win, and it is shown that they are not property because they were not in Spain, but they came from Africa. So you can't have new slaves. Only the existing slaves who exist in the Spanish territory and in the European territory, only those are slaves. Rest of the people who are free, who are in Africa, can't be brought in the Europe. So this was a courtroom drama around that. They won in the first part, and then the matter came in appeal. In appeal, there was a very senior lawyer who said that look, you are arguing on the fact that these are slaves or these are not slaves. But what are you selling to the court? What is the story that you are selling to the court? So he said that find out a person within Europe who will be able to understand these people and their language. So they tried to find a person who were able to understand their language. From them, they heard their story. And that was what they narrated in the court, where they said that they look, these slaves were in Africa. They were, this is the way in which they carried on their lifestyle. This is the way they were captured. This is the way they were brought into India, because those slaves had killed their captors. So the question on those slaves was that they have killed somebody. So they had to present a story, an arguable story, that why these black people have killed white people, which at that time was very sensitive. So the judge, the senior lawyer said, you will have to present a persuasive story. So, how was the story created? The story was created where they told them, narrated the facts that they were brought from Africa, they were on a voyage, they were kept very bad conditions, they were tied as slaves. Then, when they tried to break free, they were beaten to a pulp, and several atrocities were done on them. And this was illegally that they were brought into Europe, though they were free people. They were captured and brought into Europe. This is how they were sold. So this entire story, the young lawyer in the lower court presented only one thing, that look, these are slaves, these are free people, these people are from Africa, so they are not property. But when it went to higher forums, the entire story of those people was brought forth to create a persuasive case that why the matter, why that case of that murder should be dropped against them, and why they should be sent back to Africa. So facts are one thing, presenting a persuasive story, because if you may have thousands of facts, but what are the important facts of your case that you're going to present to the court? If you see any brief of a lawyer, it will be running into thousands of pages. But it is possible to show 5 pages and to win a matter. For instance, if it's a section 9 petition, and if you are able to show, look, this is the invoice, this is the balance confirmation from the other side. Based on these two documents, you may be able to win the case. So, what is to be presented, how it is to be presented, what is the art in which you will persuade the judge? For instance, in a section 14 petition which was argued, these were the initial days where there was a garnishi order. What happens is bank accounts there was a company in CIRP. The bank account was frozen. The bank account, there was the garnish order from income tax. That means income tax had put a stay on utilization of that bank account funds. Now this was in 2016-17. There was no law that says that this garnish order could be lifted, and this garnish order was included on this account prior to the CIRP date. So the question before the judges was that whether this garnish order can be lifted. And as you have seen right now, also there are conflicting decisions that whether PMLA, that attachment under PMLA is possible, not possible. Even today, those arguments are going on. So at that time, this issue regarding whether garnishi order continues on that account and whether the RP will be able to utilize that funds which are there in the bank accounts, or whether that income tax stay on utilization of that particular amount will go on. So that time, because the law was new, a very beautiful story was presented to the court by one of the leading senior counsels in Bombay. So he did not start by showing section 14. He started with showing the objects why income tax, why IBC was incorporated. He started by reading the object of IBC. So therefore, what he did was he said that look, as per the insolvency code, as per the objects, look at what is mentioned. They said that this law is, and I'll read that relevant portion for you. And this is what he read: an act to consolidate and amend the law regarding reorganization of the insolvency resolution and and for promoting entrepreneurship, availability of credit, balance of interest of all the stakeholders, including alteration in the order of priority of payment of government dues. So he said he started from there. He started with why was insolvency law brought into force? The fact that earlier government had priority. Then he showed that this priority was changed as per the new legislation. Under the waterfall, earlier, if you see, under Companies Act, the waterfall mechanism provided for certain other liabilities to be paid in priority. But in section 53, that waterfall mechanism has changed. And this is what was the intention of the court. And if this garnish order were to continue, then it would completely affect the corporate debtor. So he gave an emotional twist to this, because he said that if when the company is not in CIRP, it has a garnish order. Because of that garnish order, it will not be able to use any of these funds for its business. That's why his business is down. What is the reason for resolution? In resolution, you want to revive the company. But if that same stay continues, it will not be able to use any of this CIRP for the cost for running the company. It will not be able to use its account. So nothing has changed pre CIRP and during CIRP. So in CIRP, RPs are asked to maintain the company as a running company. How will they do it without the funds? So these kind of arguments. So drafting is one thing, argument in court is a completely different ball game altogether, because it is about presenting a beautiful story and presenting a beautiful, I'm not saying incorrect, based on the available facts that you have, presenting a persuasive case. And that's why you will not have to show everything, as in many people who are arguing in the court, they keep on reading whatever. If they have got 110 documents, they will read all 10 documents, they will explain all 10 documents. But that is not what is drafting. That is not where how you argue in a court. You argue showing the minimum facts that are necessary. So as I told you, that think of all alternatives and include it in your draft, but don't present everything in the court, because court will say, what do I do, what do I want to do? If they're asking a question, there will be an answer in your draft. But if they're not asking, for instance, now in liquidation, the court is asking you three things. Okay, tell me what your application is about. You will have to tell them this is a liquidation application. The company, the 270 days are over. The COC has decided that they want to liquidate the company. Either the 270 days are over, or the COC has decided that we want to liquidate the company. This is the liquidation. These are the minutes where they have agreed. This is the RP. this is the liquidator which they have selected. Nowadays they can change that. And they will say that this is the remuneration which is accepted, these are the minutes, and this is the voting result. That's it. That is all that will be required. So you just tell them why, because you have to tell them that look, this company, there are no assets, there are no assets in the company. Therefore, when you invited plans, nobody was ready to come forward. Nobody came forward. Even the promoter was given a chance. He also attended the meeting, but he did not say anything about giving a resolution plan. So you will give facts which are limited, which are essential for permitting that application to be admitted. Plus, you will give a compelling story around it, so that you will say ki you have done all you can as an RP to save the company, but unfortunately the company could not be saved. So this is what is argument. It's an art of persuasion. You have to persuade the court as to why they should consider this application, and it will require choosing the right facts which are required by the law, which are the mandatory conditions which have to be fulfilled, and putting it in a form that shows the court that you have done all you can, especially in a section 33, and that there is a case made out for giving that order to you. So these are the few rules that are there. So this is arguments in code. So how to find an argument? Argument is a crux of the whole case. So if you're going to be arguing in the court, or if you have some lawyer or representative who is going to be arguing your case, you will have to help him find the crux of the matter, because as an RP you know everything. As a CS, if you are a company secretary who is representing, you will know a lot many things, but you will have to concise it, because you have to understand the judge is going to deal with 60 matters, and that is what many people make a mistake. That for instance, the smallest application like a 252 application or a section 12 application, they argue it for 1.5 hours, and they feel, oh my god, we have made such a wonderful argument. But that is not right, because you are wasting the time of the court. The judge is not saying anything to you, not because he has liked your argument, but because he is forced to listen. So please understand, the judge who is sitting, the member who is sitting there, is going to be going to hear you because he has to. But you have to, as an officer of the court, when you are in the court, you are an officer of the court, you are there to assist the court. So if you are going to make a 1.5 hour argument for section 12, because you're not prepared, you are flapping the documents from here to there, if they're asking questions, you're taking 10 minutes to argue, you're beating around the bush, all this will leave a very bad impression. So when the next time the court may perhaps may not be as kind to you as in the first place if you continue such practices. So please understand, the courts also today are flooded with matters. They have to deal with 60 matters in the courtroom. You have to respect the court, you have to respect the time of the members, and you have to do the major part of preparation so that in the courtroom you don't waste time. So, for that, you will have to start with finding your argument. What is the crux of your case? So, I will just explain that how you start with it. Just give me 1 minute. I will just show you. So, court generally asks you, who are you? That has happened in the court, and that's why I'm giving you this example. Who are you? He said, oh, I am Mr. So and so. The court is asking, who are you? They are still not able to understand. I am for the petitioner. Who are you? So this has happened in the court. Who are you? So when the court is asking such kind of questions, they are basically asking certain things in a context. Okay, and that's why I said, when you're preparing a matter, you prepare it from the beginning. Ki, who are you representing? So if you say RP, the court will understand, okay, why is the court asking you such questions? Because court is trying to understand, now what type of matter am I going to be dealing with. So they are asking, if you're an RP, then they'll say, yes, I understand. The member will think, yes, the matter is admitted into CIRP. There is an RP, IRP stage is crossed. So RP is coming today. So perhaps for a section 19 or some other application, he has come. If it's an IRP, the court will know that either he is coming for section 19 or he is coming for some authorized representative change, which we can do in 2 minutes, or he is coming with some application because he is not able to form the COC, or some such. In some cases, it has happened that all COCs were related, all the this has happened in small cases where the entire set of creditors were related parties. So very rare, but some kind of such application has been filed. If you are a financial creditor, the court will say, okay, is it a pre-admission matter, is it a post-admission matter? If you're an operational creditor, again they'll think the same thing. If you say you're a dissenting financial creditor, they will immediately connect that, all right, that must be a resolution plan, must have been approved, and they are not okay with that, so they must have come. So their brain will start moving in a particular direction, because the members here, like for instance, if you are dealing with the 60, if there are 60 matters in a day, so 60 into 30, that is the number of matters, some 1800 matters they will deal with in a month. So they have seen the entire gamut of matters. So the simplest question that they ask, like who are you, gives them a lot of background. Getting me? So if you say majority financial traders, they'll say, all right, they must have been unhappy with the way RP has been functioning. That's why they are coming to me. If you say you're for COC, they will assume that, okay, it's regarding resolution plan, or it's regarding some action of RP that they are not satisfied with, or some action of the promoters that they feel should be taken up, or they must have been approving some resolution plan or something of that sort. If you say you're a successful resolution applicant, they will immediately identify that, yes, all right, resolution plan has been approved, or it is a pre-admission of approval, like approval of resolution plan has happened, so we might have to consider some application surrounding that, or plan must have been approved by NCLT and he's coming back to ask for certain reliefs after the approval of resolution plan. So you have to understand that members are dealing with thousands of matters. So, small thing, if you explain it to them, as in who are you, they will be able to think and put your matter in a context. So while arguing in court, you have to be extremely clear, who are you for, what are you doing. So I'm just giving you one such example, that the smallest of questions that are raised by the judge is to categorize your matter. So if you are able to give right answers to the simplest questions like who are you will be able to help them identify your matter, and your matter will move much faster. Otherwise, you will get stuck in the basics. I'm sorry, my regular presentation, something went wrong. So I had to prepare a second presentation. So just bear with me in case I have to find certain details. So this was the just one of the cases. So when you're preparing your argument, you will have to you will have to understand what is the crux of your whole case. For instance, if you are dealing with a section 14 petition, for instance, in one of the matters which was there, a bank guarantee was encashed by the guarantor, by the financial institutions, and the RP said, no, this bank guarantee cannot be encashed. And he filed a Section 14 application. According to me and according to the NCLAT, there are several decisions that says bank guarantee can be encashed because it is only between the financial creditor and the banker. The corporate, it is not an asset of the corporate debtor that is getting stuck. So, in that, if you're making such kind of a application, you will have to show that on what basis are you making such kind of application. Why? Because if you fail in making a compelling and persuasive case, you will not be able to convince the judge, and then you will lose the case. So, when you are filing applications, first stage in drafting, you will have to take care. At the time of argument, you will have to summarize what you want, you will have to summarize the case laws that you are using and why they are relevant and why the other applications are not relevant. Now, to give you one more example about arguments, that when generally a matter starts. I have actually kept a cause list. Yes, so let's look at the cause list. Now, whenever you are dealing with any matter in the court, how do you start a, like I've told you that you will have to give a compelling case, but there are certain basic things that you have to take care. For instance, for instance, I'm just giving you an example. If 204 is called out, the court will firstly see that there are three applications. So many people directly start arguing the application which, according to them, is important. But you have to understand that you have to give a context. Are we moving at the right pace? Any questions so far? All of you?
No, please continue.
Yeah. So, first, we have seen in arguments, you will have to make a compelling case for what is it that you want to present. Second, you will have to be clear regarding who are you for. Third, which is the regular, and I'm dealing with the basic things which unnecessarily cause delays and unnecessarily cause confusion in the courtroom. So I'm dealing with the most basic things, because I'm not telling you what to argue, because that will depend on a case to case basis. So now let us see this is a matter at 204. There are three different IAs which are listed. So many a times what people do is they directly start arguing. Now, say for instance, some I say I 698 is very important for the RP. So the person who is presenting will directly start arguing 698, and the court will be in complete disarray as to why have you started arguing, because court will also need a context in which they want to start. So, for instance, if this matter is called out now, they will firstly ask you that who are you for, where your authorized representative will say that he's for the RP. The other person who is, say, for the promoter will say, I am for the promoter. The other person who is for some third party or some operational creditors who has filed an application because his claims have been rejected, that person will say that, okay, I'm for the operational creditors whose claim has been rejected. So, okay, the court will understand that, all right, there are some three parties to whom I have to hear. Then the matter will move on. Now, in many cases today, in this matter, there are only three IAs. But in any standard matter, in NCLT, especially those high stake matters, high stake CRP processes, you will find that these IAs run into uh, 10, 15, 20 IAs. Like, this is the least amount of IAs that you can see. Many a times there are multiple IAs. So the court would generally, and that's why you need to know court practices of the court where you are practicing. So, for instance, if you are practicing in Bangalore NCLT, you should know what are the practices there. Because I am practicing in NCLT Mumbai, I know that this is the practice here. The court, because and this is the custom. What are the customs which are followed by the court, which you have to adhere to if you want to effectively represent in NCLT, NCLAT? So the courts will ask you that what are these three I's for. So many a time people don't study this basic and then they fumble in the code. So whenever there are three I's or there are multiple I's which are listed, you will have to explain regarding all the I's which are filed. So for instance, what will you say regarding each of these I's? So, for instance, what people do is they explain what is this I under, but section is already mentioned, so you need not say that. And then they will say what is the prayer and whom is it filed by. So, for instance, I 796 is filed by the RP. The RP has filed this application for certain relief, say section 14 relief, which they are seeking. Then this is the next I. This is 3735. It is say filed by some operational creditor because his claim has been rejected. There is a third I which has been filed by some creditor for some grievance he has against the RP. That way, once you explain what are the three I's and what are the prayers that have been sought, you can move on now. Now, after this, there are certain courtrooms in Bombay which would prefer to go IA wise. So they will say, look, these are the three I's. First is I 796, please argue. Now, in many cases, RP has certain urgencies. So if they have an urgency, this is the time when they have to mention it. So in courtroom, you will have to follow the decorum of the courtroom and you will need to know the court practices. So if you are in Mumbai, you will know this. If you are elsewhere or if you are going to say appear in a particular courtroom, I would always suggest that one or two dates link of the court is available. Please look at the manner in which that particular court is reacting, how what kind of questions they are asking, how are they conducting the court, because if you get a sense of that, you will always be able to present a case in a proper manner. And that is what is required. Because many a times what you have is you have a beautiful argument in your mind. You will say, I'll say this, I'll say this. There's like there's a dialogue like a hero gives. You have all those dialogues in mind for your particular eye for which you have an urgency. But the courtroom always starts from a different way. They'll ask, what is this eye for? What are these eyes for? What are the prayers? Why is this urgent? Why is this not urgent? And those basics, many a times people don't prepare. So that is where the problem starts. Then they fumble. Then the court says, no, 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 I don't want to hear all this. First, you explain what are these ayahs for. Or if it is a list of 20 ayahs, they'll say, I don't understand what are the prayers. You bring a list. So all that you have thought about, the hero like dialogues you have thought about, all those you will never be able to present to the court because you have not taken care of the basics. You have not taken care of what are the main things that the court will ask. For instance, they will ask whether it's in CIRP, whether it is in liquidation, whether it's a pre-admission stage, it's a post-admission stage. They have some basic questions because based on those questions, they are going to compartmentalize your matter. Okay, this is an I under which section? 30. All right, section 30I. Who is it filed by? SRA. Okay, they must be asking for an early date or they must be saying there's an urgency. Who is this application for? Promoter. All right, that means they must have been challenging a resolution plan or there must be some complications in the plan or the plan may not be according to the set procedure or there must be a procedural lapse. All right, let us understand and compartmentalize this I in resolution plan and I is concerning resolution plan. And then there are challenges by operational creditors to the rejection of their claims that they will compartmentalize in another thing. Then there are IS safe by home buyers. They will compartmentalize in another thing. So you have to first help them look at the eagle's eye because many a times for you are running the process, so you will know that look, for instance, if some bank has taken away there was a case where a bank during CIRP had accidentally taken away a huge amount of money from the CIRP company to the bank, and this was so important that the RP was extremely concerned about this because that money was required for the CIRP process and that had to be brought to the knowledge of the court. But there were 50 other IAs which were listed along with that. So if he directly started, and that is what used to happen, he used to directly start, there is an urgency in this particular I need to consider it, but the court could not hear it. Many a times it got adjourned. That was because he did not put things in context. So, how did that application finally get argued? And that is how the background work that you do should not only be with respect to the arguments, but also to give the court a perspective about your matter. So what they did was, these 50 eyes, they categorized it. How did they categorize it? That these are the eyes filed by home buyers, 20 such eyes. These are the eyes regarding PUFE transactions, pleadings are not complete, these matters can wait. These are the matters regarding resolution plan, challenges to resolution plan. This matter can be taken up on some other date. These are the eyes where there is an urgency because some bank property, some property of the company, that is that bank account, some monies have been taken away by a banker, we need to bring it back. Or there is some property which has been attached during the CIRP process, there is an urgency that will affect the resolution plan, so kindly consider these two applications first. So if you want anything from the court, if you want any relief from the court, you will also have to understand how the court functions. Because unless you understand how the court functions, you will never be able to get effective relief. Because many people say कि अरे मैंने ये बोला वो बोला पर सुना ही नहीं, adjourn कर दिया. But that is because they are missing the point. They are not understanding that look at the cause list in Bombay. How much is the cost list? He has, the judge has to hear 38 matters, in which in several such matters there are multiple eyes. So essentially it is 40, 50 odd matters that, and this is one of the short cause list. Others are running into 60, 70 matters also at times. There today, I think, because of certain reason the cause list is small. So you have to understand it from the judge's perspective, that they are dealing with multiple matters. So they will have to get a perspective. They will have to get certain basic information before they really start hearing your matter. So that's why I told you that making argument, having nice dialogues, having nice application full of facts is good, but background work has to be done. Who are you for? Why this application? How many applications are there? What is the process? It's a CIRP process, liquidation process, voluntary liquidation process. Which application, which stage has it reached? Has it reached till the resolution plan stage, or resolution plan is under consideration? Resolution plan has not been there, we won't say we are, there are extension applications which are pending. What stage of CIRP have you reached? What is it? What are these, all these hundreds of applications for? Why are some applications more important than the rest? This is the background work that you will have to do before you actually come to argument on your eye, or argument on any aspect that you want to bring forth before the court. Okay, so this is just one of the examples of the care that you need to take during the process. Anybody has anybody has any such experiences, some courtroom experiences that they want to share? All right, you're all professionals, you will have much more interesting stories to tell. This should be an interactive session. One way is not fun, because the more we share amongst each other, the more interesting it will be. Anyone, any courtroom experiences that you have? All right. So how to prepare? Now we have seen what basics have to be taken care of. Now let us go further, that you knew the law, you know the facts, but you need to apply the facts to the law, or you need to apply the law to the facts of your case. Say, for instance, if you are going to the court, for instance, to say that this garnishi order needs to be removed, you will have to give them details to the court, but you will also have to explain the facts, and they have to seamlessly connect. So how do you do that? First, for instance, in one of the matter, as I told you, that the R that during the CIRP process, a bank guarantee was encashed by a financial creditor. That bank guarantee was encashed by, say, ABC Bank Limited. So this financial creditor, Mr. A, went to the banker. They said, "You have given a bank guarantee. So bank, please return, please give me the money." And the bank wrote to the RP that they are enforcing this bank guarantee during the CIRP process. Therefore, it is wrong. Now you have to explain this to the court from the side of Mr. A, that this is incorrect and this bank guarantee does not constitute an asset of the corporate debtor, because I am asking this money from the bank who has given the guarantee and not from the corporate debtor. So it is an asset of the bank which from which I am seeking money and not the asset of the corporate debtor. So this is the fact of the case. But to that, whenever you're applying the law, what people do is they read out entire judgments after judgments. So you will have to find crux of the case law that you're referring to, which is called the ratio of the case. So you will say, look, this is the Balco judgment given by NCLAT, where they have specifically said what are the assets of the corporate debtor, what are not the assets of the corporate debtor, and whether a bank guarantee can be encashed and bank can be asked to honor its payment, and this can be done, and therefore I can validly encash my bank guarantee. So you will know the law, you will know the facts. You will have to show that these facts are exactly applicable to the law. And this especially happens in PMLA matters. In PMLA matters, there are several judgments, but when ED has attached your matter, ED has attached certain asset, you will need to show that, look, ED attached, say, my asset of my company during CIRP process. Even in this case law, the attachment was during CIRP process. This was a provisional attachment. Here also there is a provisional attachment. Or there was order of PMLA authority. Here also there is a order of PMLA authority. So these kind of similarities have to be pointed out, because if there is a difference, for instance, if your attachment has taken during CRP process and you are showing some order of CIR of attachment which has happened before CIRP process, and that order gets changed, you will have problem. So you will have to first show that yes, this is the case law which I am applying, these are the facts similar to my facts. There are other case laws in PMLA regarding attachment which go against, but those are different in terms of facts. In my case, during CIRP, there is an attachment, so I am challenging it. These are the attachments that have taken place prior to CIRP. So all these 1, 2, 3, 4 case laws do not apply to my case. So this kind of application of law with facts has to be seamlessly merged together while you're presenting your arguments to the court. Now, for this, as we were taught as lawyers, is when you are arguing in the court, you have to read up the commentaries for that section for a clear and better understanding. But unfortunately today, the IBC law is such that commentaries would not be enough for you while you're arguing. So I would say, rather than commentaries, you will have to go to websites like IBC Law or Live Law or SAC Online or even ICAI, IIP has a beautiful set of newsletters and documents that record the latest case laws that are there on multiple points. So you will have to rely on them to understand what is it that is the law today. Because as I told you, law over time and the understanding of law changes. There are some conflicting decisions Now, PMLA is one such example. They said attachment can be done, then attachment cannot be done. Provisional attachment is okay, provisional attachment is not okay. All these laws, they have been slight variations. So, if you are dealing with any such aspect, which is a contested field of law, you will have to be updated regarding all the judgments on the topic and what are the judgments that are suitable for you and what are the judgments that are not suitable for you. And for that, rather than commentaries, I would also always suggest go to the go online and just search. For instance, whether on the basis of a lease agreement you can maintain a section 9 petition. That is the question. So the best way to find an answer is Google search it. At least you will find something or the other which will give you a headway to delve deeper into that topic, which will help you in arguments. Because many a times you don't understand where to start. So Google search today I find is the best way to search law points on a particular topic, because that will give you a headway that yes, there are some NCLAT decisions, there are some NCLT decisions. Then you start checking whether these decisions are challenged in the higher forum or not.
But now you should use ChatGPT.
Very true, very true. I haven't used it myself, so I think that is the next AI is the future. So I think we should all really look into that. So moving on, how you structure your arguments to bring out the decision of the case law in your favor. Now, this is very important. What people do is they directly, for instance, if you are arguing a petition or an application, you will directly jump into the facts. So many a times it will be best that you put forth your propositions. So, for instance, if I am arguing a Section 9 petition, what we can start with is that this is a Section 9 petition. This is with respect to goods which I have supplied for a period of time. You can say that there are three major things on the basis of which put it in numbers. It will be easier for the court. So, there are three things on the basis of which I am going to fortify that this is a debt and default. So that way, whenever you're arguing, rather than just going on and on and on, you give courtroom a contour. That means you should tell them that these are the three things, these are the three propositions on the basis of which I am going to argue my case. So, for instance, if there's a Section 9 petition and you are challenging it, so you will tell the court that, look, I am arguing this matter and I have three basic defenses against admission of this Section 9 petition. One is that it is hid by 10A. Second is that it's barred by limitation. Third is that there are disputes which have been raised prior in time. And fourth, say suppression of facts. So, if you give these contours of your argument, they will give court some satisfaction, because court doesn't want to hear long winding arguments that go on and on and on. So if you look at how certain senior counsels present, they will always give them, these are the only four things I'm going to argue. So when you say two, I am arguing limitation, so they know, okay, I have to hear you for the next two propositions, that's it. Okay, third point, okay, almost done. Now he will keep quiet after the fourth proposition, right? So those contours help the court appreciate your arguments, and they know that you will stop after the fourth. So they have something in picture. So whenever you're going for a picture, you will see कि कितने घंटे का picture है, एक घंटे का, 3 घंटे का है या 2 घंटे का. You decide on that basis whether you want to hear it today or later, whether you want to see that picture today or later, isn't it? So similarly, when you give these propositions that this is how much I'm going to argue, the court also knows that, all right, and they will have that patience to hear you. But if you go on and on and on, they might just ignore what you're saying, right? So this is about propositions. Now know the subject matter and law governing the case thoroughly. We have we have, I think, at length dealt with this aspect. How to make your arguments compelling. As I have told you, the basic principle that the person with the best story wins. So if you are able to persuade the court with your argument, you will have to give a compelling story. For instance, if the promoter comes with a story that look, this was a company for last 30 years I have been running this company. In this company for 29 years there was no NPA. The NPA has just started now. I was in financial difficulties, that's why I couldn't do. Now I have an investor, so please give me a chance to revive this company, because I this company has been started from scratch. This, for instance, I'm just giving you arguments which promoters have made. So this is a company which is in such a sector. For instance, it is in the automotive sector, and there are very few companies who are giving the kind of services I am giving, a very specialized service. So kindly give me an opportunity to revive this company. Don't let the company be liquidated. Allow me to give a resolution plan. This is a compelling argument from the side of the promoters, and it's an MSME. So the court will ask you that why not? Why have you not given him a chance? So there, your compelling argument or your story will make a difference. Because if you say, oh, this is a COC has accepted, so there is nothing to be done about it, just that argument will not help. They understand that that is the law, but along with that, what is your compelling argument? You can say that look, the matter has come before the court after 270 days. So the promoter had a good 270 days in which he could have given the resolution plan, but he sat quiet all this along, and today when the matter is going for liquidation, he has come before you. You can say that during the CIRP process, he has put a lot of impediments. He did not give us the documents. For 3 months, we were without documents. He did not cooperate in the process. He did took all efforts to try and sabotage the process. And when the matter is going for liquidation today, as a matter of last resort, he is trying and putting forth this document that I am an MSME and I want to save this company. No offer for an OTS was ever made. He did not propose. The matter went for invitation of resolution plan 3 times. We invited resolution plan. All the meetings he was present. He did not utter a word regarding the fact that he wanted to settle. And today, for the first time, he is raising this argument and coming before the court. So arguments are, along with this, you will say that's why 270 days COC minutes approved, 66% consent. So facts and law are one thing, the story and the persuasive way in which you present your arguments are a different thing altogether. And that is what you have to do when you're presenting to the court. Even as an RP, when you are there in the court, you try to, before going into the courtroom, please understand that even if you have an authorized representative, they may still ask the RP, IRP certain questions. So, not just your authorized representative, but you also have to be ready with certain facts, which is at the drop of your hat. You need to know all those, because the court may ask you, what have you done regarding this? So, you should be immediately be able to give a nice, compelling story about the efforts that you have taken, because many a times RP take efforts, just that they are not able to present their efforts to the court, that what is it that you have done. Many a times they go out of the way to kickstart the factory, they bring back the workers, there might be dharnas where they try to reconcile, mediate with the people, start the factory. Then the electricity must have been stopped, so you will take efforts to go to the electricity board. It may not come to the filing of an IA in NCLT, but you may have done multiple visits to the MSEB and ask them, to the electricity board, and ask them to start. You must have gone to certain people who have stopped the account, shown them the law, and then the account would have been made operative. So many things have been done by you as an RP. So when things come to court, have all this background ready, because many a times there are certain black ships even in the resolution professional, because of whom there is a mindset that resolution professionals are not doing their bit for the company. So if you have done a lot of things for the company, to safeguard the interest of the company, to start the company, to get contracts for the company. You need to present those facts to the court if required, because they will ask, the matter is going on and on, two times exclusion of time has been sought, why are you asking again, what efforts have you taken? So you need to be in a position to give a compelling argument to the court to show the extent of efforts that you have taken to resolve the company and to manage the company. So doing it is one thing, presenting it is another thing. We are not talking about the efforts that you have done, because unless you tell the court, nobody else is going to tell the court what you have done. It will just remain in the background. So when you as an RP is ever attending a proceeding, be sure that you have all these things with you. I would call them, you have all the bullets with you. When if required, you fire. If not required, keep them with you, right? Because courtroom mein, once the matter starts and it is reserved for order, then thereafter you can't do anything about it. So whatever you have to say is in that 10 minutes or 15 minutes of hearing, or say half an hour, 1 hour of hearing. When the matter is taken up for final hearing, you need to be ready at that very moment, because that is the time, if you say certain things, it will have an impact. Then again, how to recognize and discard weak arguments. So when you file an I, there will be multiple propositions that you will make. For instance, if you are arguing against a section 7 petitions, many a times your the corporate debtor will say कि अरे इन्होंने लोन मेरे को 10 करोड़ का दिया था, इन्होंने क्लेम किया है 20 करोड़ का, तो ये सब गलत है. You will need to know what are the weak arguments. The clients may insist कि नहीं ये डालो आप, but at the time of making the arguments, you present it in the logical sequence. Okay, just because you have put certain propositions first, it is not required that you take them first during your arguments. You present the best foot forward in the court. So if you have, say, 10 propositions against your Section 9 petition, you will find out that which is that one proposition which, according to me, is so strong that this petition can be dismissed. Present that first. Second, find out that okay, these three propositions are good. If the court buys them, then I am through. You put those thereafter. If you feel certain arguments are so weak that it will not stand in the court, you can ignore those arguments, because if you talk too much, then you are giving certain facts. The court will remember what happened in the end. It will give ammunition to the other side to harp on those weak arguments of yours and say there is no case made out. So again, we come back to the same proposition. Drafting and putting facts in your application is one thing, arguing in court is a completely different ball game altogether. You need not present everything, whatever is weak, whatever may not sustain, against whatever there are case laws that have come after you have filed the application which go against you. Do not present them. Present those aspects which are the strongest for your application. The opening sentence of your argument should make an effect. Now, this is something which is which is an American concept, that you must have seen all these movies, like all these several uh, series that are there, like Boston Legal. If you ever heard Boston Legal, there is this person called as Alan Shore, who is an extremely good litigator. So his opening statements are the one that make maximum difference. So when he starts with a very beautiful proposition as to why his clients are innocent. So this Alan Shore is dealing with all the criminal matters, and in US you have to get an opening statement to the jury. So there was a very beautiful way in which he has presented to the court, as in a summary, why their application should be accepted. So when you are also going to NCLT or NCLAT, rather than directly starting, you can always say that this is the I, this is the prayer that I am asking in this I, and in 2 lines or in 3 lines, why, according to me, this I should be allowed. If you do that, the court will be able to get a proper context and you will be able to get released faster. You will have more effective hearings in the court. So that opening sentence, though that opening line, as we say, is nothing that is very regularly followed in India. You can see Boston Legal to see how these opening arguments are made. But if you are able to summarize in a capsule at the start of your eye or at the start of your hearing why this application should be allowed, or why, if you are for the respondent, why this application should not be allowed, and then go deeper, the court will be able to appreciate you better. Because if the court is able to, today it is about hearing, the court is hearing both sides and taking a call. So argument has become an extremely important part of winning a case. Because when you are going to court, it is like a war. And as they say, I have just copy pasted a nice saying: to know your enemy, you must become the enemy. So you need to know what the opposite side is going to argue. It's like a war that you're going into when you are arguing. You're like a soldier standing at the forefront, facing bullets which are coming from the opposite side. So, how you present a compelling argument that will make the court feel like hearing you. The court has to hear you, but the court should feel like hearing you. If they feel like hearing you, they will be able to appreciate you better, and your chances of winning this battle. Why do they call it a courtroom battle? It's like war. All the principles of war are applicable. So if you want to win that war, you have to grab their attention. And how to do that? There are multiple things which, if you look at the manner in which these cases are presented, you will know what to do, what not to do, which will help you in your own matter. Now, this is another quality of a lawyer which Kapil Sibal had mentioned in the court. He had said that Lord Denning, who was like a luminary in the field of law, many quotes of Lord Denning are very, very famous. So Lord Denning was asked that what is the greatest quality of a good lawyer? And you, as an RP who are presenting in the court, I would say, what is the greatest quality of a representative of a court? You are also an officer of the court. So he said courage. Courage with conviction. So you should be convinced with the eye that you with the release that you are seeking. You should feel and you should have that conviction in you, because many a time the court will contradict you. They'll say, no, no, what you are saying is incorrect, we don't agree with you. But you should have that courage to present your side, to move on and present your side to the court. Inform them that, my lord, I understand that this is what is coming from the court, but please see one, two, three, four things that are in my favor, and kindly consider these facts also for this. So you will have to have that courage in the courtroom, because many a times people get troubled if the court says, no, this is a hopeless application, we don't consider this, we don't think this is maintainable, please withdraw this applications. There are times when, out of fear, these applications are withdrawn. But if you have conviction in the case, which will be based on the research that you do, the efforts that you have put in your eye, you will be able to inform the court politely that, yes, I understand that this is the court's perspective, but I feel that this application is correct. And what are the reasons? Because this will happen, especially in a 19 application, the court will get angry at you. Why have you filed it at such a early stage? Within 15 days you have filed this application, why have you come so early? Why don't you take efforts? So there you will need to have the courage and the conviction to explain the court that what you have done is the right thing. These are just some of the things, as in, out of advocacy is never ending. We can find multiple such uh, incidences that we can quote. But I think for today, we can close it and leave some time open for certain questions if anybody has, and then we will close today's session. Thank you very much. Anybody has any questions? All right, then what we can do is we can close for today. Thank you very much. If you have any questions, you can just post it on LinkedIn. I have a LinkedIn profile, so Prachi Wazalwar, you can check and you can post your queries there if there are any. And it was really a pleasure to be amongst all of you. If anybody wants to share some kind of experiences they had in courtroom, you're welcome to do it now, or we can end this meeting. Anish ji, Ajay ji, any interesting aspects you want to share?
Good evening, ma'am.
Good evening.
Ma'am, my name is Sean. I'm a chartered accountant as well as an IP. Ma'am, you rightly mentioned that you had to speak with courage and conviction. At times, it feels that the court is very particular that you must withdraw, you must act accordingly. So, especially we being not lawyers, we are only chartered accountants. We do have the fear how to stand against the court. So, how that courage will come in.
It will come with time, but please understand, the court respects you as an RP, but you will need to have that background, because what happens is many a times RPs come unprepared, they are not able to answer the courtroom, so somewhere the court feels that they are not doing the job. Many a times as a CA you are doing your job, you just have to, the way when you give a resume, you will have to show what you have done. Correct? So when you're going to courtroom in a CRP process or liquidation, you will have to show what you have done. Correct? And if you are making a proposition, you will have to give some background, and you have to be you will have to be as ready as your authorized representative. You will have to be with him for some time. Only then you will get that courage, right? And if you're not prepared sometime, because see, everybody has certain commitments because of which they are not busy, you always tell the courtrooms that several things have been done today, because I'm pressed for time, I could not do it. You should not technically say that, but if at all something like that happens, there are certain reasons because of which you could not prepare for the matter, you can request the court, apologize to them, and take time. The judges that way are extremely considerate, they will consider.
Thank you, ma'am. Thank you. Thank you.
Thanks, Sean. All right. I think we'll just take a. All of you, can you just open your video chats so that we can just take a photo? If you can just put your videos on, we'll just take a photo and then we will break for today. This was not technically an IBC session, but a session about the courtrooms. I hope uh, this was something that you enjoyed. And especially after lunch, it becomes too difficult to, to hear a session.
Ma'am, but it was very interesting.
Chalo, I'm happy you liked it.
Yeah, very, very much so.
Thank you so much. Thank you. All right. Thank you, all of you.
Thank
It
you,
was
ma'am.
a pleasure
Thank you.
to have this session on the Women's Day. Best of luck to all the women RPs and CAs in their endeavors in the profession. All the best. Thank you so much.
Thank you.
Shall we conclude now?
Yes, yes.
Okay. On behalf of Team ICSI IIT, I would like to extend my sincere thanks to you for addressing session on the topic drafting, pleading and arguments before NCLT and NCLAT. Thank you very much, ma'am, for sharing your experience and learning and making the session interactive and insightful. Further, ma'am, you are requested to please share the PPTs also.
Sure.